Good morning, Lila. It's so nice to connect with you again. We had such a good session with you back at the Charleston conference. And I'd like to take some of those points and thoughts a little further. Thank you for agreeing to do this. You told us a little bit about your background and the powerful influence of books on your young life. Can you say a little bit more about what brought you here through law school, not just the Narnia books in your childhood, but through law school and into this role with your great passion for libraries and reading?
Absolutely. So first of all, I had an absolute blast at the Charleston conference. It makes me all the more want to come in person someday. But what a great crowd and what a fun session. So just thanks so much for inviting me. I'm really so appreciative. My passion for reading really, it's just been a through line of my whole life. But in terms of where it got activated in a more, let's say, professional sense, really was in law school. So my freshman year, or they don't call it freshman year, first year, 1L year of law school, I did the standard legal research and writing course. And our teacher one day brought us physically into the library. And she showed us the books where all of the cases actually live, right? Because for the most part, what we do is LexisNexis and Westlaw and database researching. That's a huge part of what the sort of legal research infrastructure is. But she brought us in and she really showed us the books and how to use those primary research materials. And she gave us this warning, if you will, where she said, listen, you will not have access to LexisNexis and Westlaw for the rest of your career. I mean, maybe if you go into big law or, you go work for a well-heeled organization, you might have some access to Lexis and Westlaw, but you will not have the sort of all you can eat version that they give you in law school. They really give you everything, and it's a mother lode of amazing resources and information. But in the real world, it's extremely, extremely, extremely expensive to have that kind of access. And so what I started to put together and started to realize was that access to research materials, access to even primary source materials like case law, which, that's public information, that's in the public domain. There's no copyright interest in those materials. Nevertheless, it's not readily available to regular people most of the time. You actually need access to the physical books. You need access to the library. The library is the thing that can get you access to justice at the end of the day. That in my mind at that point, it really, this access to knowledge, access to information, access to research materials became paired with access to justice, access to power, access to the ability to change the circumstances of a group of people or of an individual in the world. So it was in that process of going through that legal research and writing course where I really made those connections. And I began really thinking about access to knowledge as more of a social justice kind of issue than I had understood it previously.
Okay, well, thank you. Thank you for that. You described for us in a general way the issues that are at the heart of the lawsuit of the publishers against the Internet Archive. Can you just quickly review those for the audience? There are people who may have missed your talk, although we'll make them go listen to the recording, but just be helpful to have it here as the basis of our further conversation.
Right. So the Internet Archive for the past decade has been loaning out digitized versions of the books that it owns to one reader at a time. mimicking traditional library lending of, we own one copy and we loan it out to a person, and then that person brings it back and we can loan it out to the next person. So this system, which has come to be called controlled digital lending, has been in place for about a decade now. And this is the practice that is at the heart of the lawsuit that the four really big commercial publishers have decided to bring against the Internet Archive. The question is whether libraries are going to be able to transition their traditional library function of lending into the digital era in a way that preserves to the library their ability to own, control, and make use of all of the available exceptions and limitations in the copyright laws, for example, for uses like interlibrary loan and preservation and those sorts of things. Or what the publishers are trying to do is transition libraries in the digital world into a completely new model where it's terms and conditions apply. It's not the library owns and controls their own collections. The publishers get to dictate the terms and say, this is how many times this book can be lent. This book is available and that book is not, et cetera, and so on. So it really sort of situates the curation and collection management strategies of libraries in a really different place. And it also really takes a lot of the ownership and control of library collections out of the hands of libraries and puts it in the hands of, frankly, commercial players who have a really different mission and a model than what libraries have. And that's really what's at stake here, is whether libraries are going to continue to be able to buy, preserve, and lend books in the future. I mean, whatever the format may be. But that's sort of the core function of what libraries do. And that's the heart of what's at issue in this lawsuit. And the way that's playing out is the 4 factors of fair use and all of that. But really, when we're talking about what's the heart, the sort of real question, it's that what's the role and function of libraries going forward, and who gets to decide?
Interesting. So all of this could just go away if, well, no, tell me if it would just go away. If a license agreement that a library signs for access to these books or whatever would say, and you may deal with them the same way you do with print materials, would that solve the problem? Or not quite?
Look, I mean, as a practical matter, yeah, it could, right? So if we all just agreed, right? Everything can always just be agreed upon. The issue is we don't agree. The publishers do not agree that libraries can just do with digital materials what they could do in print. That is in fact the fundamental disagreement that we have in this lawsuit. But of course, if we all just agreed to it, yes, this lawsuit would go away and we could all go about our merry business, and libraries could be libraries and publishers could be publishers and readers could be readers, and nobody would have to go to court.
Well, one difference, still the one small or big difference being that this would still be subject to a signed license agreement.
Right, and so with the idea of an agreement is this idea that it could be changed or revoked or something at some future point in time. And one of the core ideas of ownership is once it's mine, and as long as I'm not doing anything illegal with it, and that could include anything from using it as a murder weapon or violating copyright. I mean, right? So we understand that we can't violate the law with our property, but we also understand that when we have property, we have certain things we can do with that property. And our society has been set up in such a way that we want people to be able to do with their stuff as their expectations have aligned. So for example, many people are very surprised to learn that all of the hundreds of thousands of dollars, perhaps, or probably not hundreds of thousands, but many, many, many hundreds of dollars that they have spent purchasing Kindle books, for example, that can't be donated to a library. That can't be given to their children. That just evaporates upon their death, or there's no way to transfer that. And that's something that surprises people when they find out about it. It's not something they're thinking about at the moment of purchase. But I've talked to people that are like, oh, so where I was able to like inherit my father's record collection, or where I was able to, inherit my parents' books from, their house or whatever. That's just not something that is going to exist in this future world of digital, or at least under the current system that everything requires a signed license agreement. So it really does feel like we are in this fundamental shift of a real policy question and a consumer protection question about like this broader question of digital ownership. And obviously library ownership is one flavor of that. That's quite important because libraries play this, very special role in our society in terms of access to information and knowledge. But I do think there's a lot of really interesting policy questions that are bubbling around, like right to repair issues and all those things, right? People are surprised when they learn they can't repair their tractor because there's software in it, right? And it's like, wait, is that how it should be? That's weird.
Yeah, no, fair enough. I think maybe the issue is that as long as we are signing that piece of paper with its own set of arrangements, however enlightened they might be, there might still be some residual problems around that, because we're not governed by any shared general legal understandings broadly based. I think that's a very interesting and subtle, but maybe not so subtle kind of issue. Anyway, I've kind of sent us down a bit of a rabbit hole. I remember you saying in the Charleston presentation that these kinds of litigations can take many years. You might have even said something like 10 years, maybe just flippantly, but that's not uncommon. I think of various, copyright issues that have gone on for that long. Can you describe the stages of such a lawsuit, what the next steps are? How do we proceed down this path? And why the heck does it take so long?
Sure. So the first phase is what's known as discovery, which is the phase at the trial court level where all of the facts at issue are established. And that just takes a lot of time, especially in a very fact-specific kind of case like fair use. Fair use is always a highly fact-specific analysis. And so the parties really have to spend a good deal of time. For example, in this case, I mentioned there are 127 books at issue in the case. So we need to know a lot of facts about each of those books, and each one in some ways is different. And in some ways our use is the same, but each one is sort of a different place in the market and so on. And so there's a lot of factual development that has to go on in a fair use case in particular. And so, this lawsuit was filed June of 2020, and we are still in fact discovery right now. And it probably is going to keep going for another few months, right? So it takes fully a couple of years to really exchange all of the documents, have everybody review the documents, and ask people about the documents and all of that. So that's a very in-depth part, and it's all behind the scenes, right? None of that is information that's out in the public. So basically, like, the lawsuit is filed and then everything goes quiet for maybe years. And everybody's like, whatever happened with that? Well, that's what's happening. Is all of that. And then you get your expert witnesses and all of that stuff. Then the next phase in in a lawsuit like ours. So I'm giving you a really particular for a lawsuit that's like this sort of a fair use kind of a case. Obviously, other types of cases can go in different orders or whatever. But so the next phase will be what's called dispositive motions, or each side will ask the court to decide the case basically on the papers, meaning the Internet Archive will say, dear judge, there are no material facts that are in dispute. We know what the facts are. We agree as to the facts. What we want to know is how the facts apply to the law, and how the law applies to those facts. And so we are asking the court to decide, based on our arguments and our evidence, that the law favors us. And the publishers will make the same arguments on their side. And then what happens is there will be a volley of replies and replies to the replies that will happen in probably a burst of 3 or 4 months. And during that time period, there's likely to be, that's when the news media will maybe pay attention, and academics may talk about it, and then you'll hear things during that time of the filings. Then we wait. We wait until the Southern District of New York makes a decision. They may ask for oral argument. I think in a case like this, they would likely do that. So that could take anywhere from 3 months, 6 months, whatever, from the time of filing. There will be oral arguments. And then we wait again until the court comes out with a decision. And just given 2020 and 2021 and the pandemic, as I understand it, things are pretty backlogged. So it can take anywhere from 6 months to 2 years for a decision to happen. And then when the court has made a decision, the parties will decide whether or not to appeal that decision.
So wait, are we now in about year 4?
No, right now we are in.
No, in where you've gotten this to in your narrative.
Correct. Yes. So
waiting for
the first 2 years-ish is discovery. Then the next year-ish is filing motions and oral arguments. And then maybe like 6 months to a year after that. So like year 3 or 4 is you get a decision. And then there's, a timeline to appeal, which is usually, I think, can't remember, it's 45 or 60 days. But there'll be a window of time where the parties will decide whether to appeal. And then the court then we would move into an appellate process where you go through the Second Circuit, which at that point is briefing. There's no new facts usually that need to come out at that point. But what can happen is the court can decide, and this is what happened in the Georgia State case a number of times, was the court could say, the district court did this process a little bit wrong, and they didn't analyze this particular set of facts appropriately. So we're going to send it back down to the district court to decide using a different set of rules, or maybe we need more facts on this particular issue. So then it could go back into the trial level. And so it can sort of go back and forth between those different levels, depending on what the appellate court thinks it needs to make a final resolution. And so that happened several times in the 11th Circuit with that Georgia State case. And then, of course, with cases like the Redigi case, the reason that took so long was very impacted by the Redigi's bankruptcy issues. So kind of depending on what's going on with the different parties, things can just drag and drag. So that's where I don't think that we're going to see a definitive resolution from the courts on this issue for at least a few years. We're looking at least 2 to 4 years, I think, would be like a conservative estimate of how long from now it could take.
So let me just ask a small question. I think in the Georgia State case, there were 100 books. You've got 127. Who chose those? How were they chosen?
So the plaintiffs choose. So that is entirely out of the hands of the library or the court. It is exclusively up to the plaintiffs to decide which books they want to assert. And they have whatever reasons they have for choosing the specific books that they have chosen. We could read tea leaves and think about it, but I have no special knowledge of why they chose the books they chose in our case or in the Georgia State case.
So it's not like choosing a jury where both sides.
No.
Okay. Well, most of us don't know these things.
Yeah.
Let me ask you another little picky question. As the years go by, do some of the players change? Maybe you get another great opportunity and you join a different project or firm. Maybe the judge is promoted. People change over 5 to 10 years. Does that affect the proceedings at all?
That's such an interesting question. Certainly changes in personnel could absolutely shift, legal strategy, could shift the likelihood of settlement being reached. Certainly, like on both sides. At the end of the day, it's all people, right?
Yeah, exactly.
Right. It's companies and organizations, but at the end of the day, we're all human beings. And so each individual person has some small role to play there. So changes in personnel certainly could change. However, it is very difficult once the sort of facts of the case are established to change what is before the court. So unless the parties both agreed for example, a thing that parties have agreed in the past is like, we agree, judge, that the digital millennium copyright is just not an issue in this case. And so that claim that's in the complaint, we're dropping it. And we're just going to move forward as if that was not there. So the parties can decide to drop claims at any point. Adding claims or adding new facts becomes increasingly more difficult over time.
Yeah, makes sense.
Yeah.
Thank you for that.
Of course.
You were on a panel with Kevin Smith, who was talking about ebook legislation in Maryland and New York. Do you see a crossover between your two topics?
Yes, and this is extremely timely. I don't know if you saw that the AAP actually filed a lawsuit against the state of Maryland to try to prevent the implementation of their ebooks reasonable licensing law. And I will say that reading the complaint in that case read very, very similar to the complaint against the Internet Archive. There's a real, so yes, there is a lot of overlap here, right? The publishers, this publishing industry represented by this powerful commercial trade industry association of the AAP, wants the world and the market to be a certain way. And they are bringing all of their power and resources to make sure that the market goes in that direction. And they are using all of the tools that they have, where libraries are trying this experiment and state legislators are trying this experiment, like publishers are like, absolutely not. We get full and total control over whether and how we deliver materials, and states, you can't do anything, and libraries, you can't do anything. This is purely in the purview of the copyright holder. And obviously, I think that is it's an inaccurate reading of what our copyright system is, and what it does give to what the sort of government grant of a copyright monopoly gives to a publisher is not unlimited. It's limited in many ways for important reasons. Many of those reasons are filled by libraries, right? So that the public has access to information and resources. So I identified at the beginning sort of what's at the heart of our case is this question of sort of what are libraries going to be in the future in the digital world. And this lawsuit and this legislation, it's the same question. It just sort of is relating to different types of collections or format types, right? So the ebooks legislation is about basically what we're going to call either born digital materials or materials that are already in a digital format when they reach the library, whereas the controlled digital lending case, our case, is about what libraries can do with the physical resources they already own and whether they can make use of those materials in traditional means, but using a different format.
Yeah. Yeah, I think we all, or many of us, saw that announcement yesterday, and I said, yeah, it almost was inevitable that this would happen. And here it is, one of the questions that has come up, or one of the statements I've heard, probably more from publishers, is that the Internet Archive really is not a library, and that that's part of the case. Do you want to talk about that for a moment?
Yeah, I mean, look, it's a cute legal tactic that has no basis in reality. They would win their case a lot easier if it turns out we're not a library, but there's no question of whether we're a library. We've been operating as a library. We've been recognized by the state of California as a library. We are a member of library associations, so we're recognized by peer institutions as a library. We get grants like we're a library. I mean, we're just, all of the players in the field know us to be a library. We act as a library. So there just really isn't, there's not a real question. I think it's more of a PR tactic. So the thing that I've seen them do is they say, real libraries license books. So what they're trying to do is define libraries by the fact that they license books. And I mean, libraries existed before licensing. Libraries existed before, so I think there's, again, it's sort of a PR sleight of hand thing to question whether the Internet Archive is a library, because there really is no question. But yeah, it's an effective social media talking point to say real libraries do X, the Internet Archive doesn't do X, therefore they're not a library. But who gets what's a library?
Real libraries are to some extent defined as having very tangible collections. You can walk into them and you can see them. I actually years ago did walk into the Internet Archive when it was in the Presidio, I think, and I did see a lot of books on the shelves and things were happening to the books, but they weren't patrons in the same sense as you had in the San Francisco Public Library or whatever like that. Anyway,
Yeah.
I think that's interesting.
Yeah, right. Like the model is different. The access model is different, but the in terms of you don't check out a physical item, but you can go to the Internet Archive. You can consult our physical collections. We have a special collection of 78 RPM records, like fragile and delicate materials that like exist. Like you can go there and look at the things and hold the objects. Like, it's more of like a rare books collection kind of library in that way, where a lot of the materials that we hold are rare and or like obsolete formats and things, and so those kinds of things are preserved in a particular way, but they are available, but they're available in a different sort of way, I guess, than sort of like you read a book and walk out the door with it. Yeah.
So to circle back to the beginning when we were asking about you, you are what I very complimentarily call a force of nature. And I always wonder about forces of nature and whether they have downtime. And if they do, what do they do in their spare time? I think you actually may have taken a few days vacation last month, if I remember in our exchange of emails. But what do you do when you're, in the 5% or 2% of your time when you're not, pursuing access to knowledge on behalf of the rest of us? Pets,
I do. So yes, so I will say I have a dog who I am deeply in love with and obsessed with. And so one of the things I do to unwind and relax is walk my dog or snuggle her, or just kind of generally spend time in the company of a sweet and gentle creature. So that is definitely one thing that I do. I also I read a lot. I am in several book clubs. I love reading. I love talking about books, and I love engaging with ideas. I'm in a science fiction fantasy book club, and so even when I'm not sort of fighting for access to knowledge, I'm like doing the thing that I am trying to fight for people to have access for, because I think it's what lights me up and gets me like excited to be in the world. So I do spend a lot of time on that. I am also a singer. So I sing basically as much as I can in whatever ways that I can. Haven't been able to do that the last few years, sadly because of COVID. But I am really hoping that I will be able to get back into my choir and singing again soon. Those are kind of the daily things that I like to do. I also do like to travel, of course, and just go spend time in the sunshine.
Great. Well, I hope you'll get more of that. And it sounds like the next time we have you, well, we can meet some of your recreational needs. We can have you come out to Charleston, so that will fill the travel part of your life. And then in addition, we could even have you sing at a plenary session. Now that would be different.
Wow, that would be different. Actually, what's fun is I do often sing at the Internet Archives. Like we have a Christmas talent show, and I'm classically trained and sing opera, and so I also sing like cheesy pop songs and all of that stuff. But when I break out the party trick of singing an Italian aria, often it is a little bit of that is something different. So you can actually find some of my performances on archive.org if you just type in my name. I think you'll just find videos of me singing Italian arias. I'm not professional. I will say I'm not that great, but it's a fun party trick.
Well, so we won't ask you to sing. We'll just close the interview without that, but we will not forget. So I think I look forward to having your interview up online, along with your plenary talk at last month's Charleston, which is already there. And let's close for the moment and wish you, say thank you to you, and also wish you a very nice holiday season coming up, and to see more of you in the new year, and lots of success to you.
Thank you so much, Anne. This has just been a real pleasure, and happy holidays to you as well.
Likewise. Bye-bye.